Professor MANEKA Shastram on behalf of the Media Law and Ethics team. Professor MANEKA Shastram completed a BA LLB from the Government Law College, Trivandrum, after which he worked as a moot court trainer at Sri Narayana Guru College of Legal Studies. While practicing in the chambers of Advocate Mr. R. Ram Mohan, later she pursued her LLM from the University of Cambridge, pursuant to which she practiced before the High Court of Kerala. She then went on to work with OP Jindal Global University as a senior research associate, faculty coordinator, faculty director of the Woodcourt Society, and as an assistant professor of legal practice. She is currently the assistant dean of Jindal Global Law School. Once again, I take great pleasure in welcoming you, ma'am. Last but not the least, I welcome the participants who are ever so eager to learn more. And with that, I shall conclude. Thank you, one and all.
Thank you, Niranjana. That was a good gist of an introduction as to who I am. But I should tell you, I'm not the assistant dean because there are a lot of assistant deans in Jindal. I'm just one among the many. So yes. Okay. So thank you for your warm welcome. And I should share my happiness and pleasure in being able to join all of you today, because I'm sure this is my alma mater running the program, and to come back and be able to contribute in this way is also a very happy, proud moment for me. I'm not sure whether Professor Meena Kumari ma'am or Hima ma'am is joining us today, but in spite of the fact they're present or not, thank you for this great opportunity. They've taught me, and I'm incredibly honored when they invite me back in some way to give back to all what I have received from the college. So thank you, and thank you everyone for having me. So we have today, whatever I'm going to discuss with you today is on trial by media, or media trial, as you might have heard of it. And this is a very hot topic. This is something that everybody likes to discuss and relate to. And just to share my enthusiasm, Krishna was my student at SN. Hi, Krishna. I just saw your ID there. So, and sorry for that disturbance. So, yes, coming to trial by media, again, a very hot topic, a hot point of discussion. I'm sure you've all heard of it, and I'm sure you've all read different variations and varieties of it. So what is basically understood by trial by media? Now, trial by media, is it possible to have a trial on media? What kind of trial, if so, if at all it's possible, what kind of trial happens on media? And what are all the platforms that you want to call as media? There is the newsprint, there is the very physical video-based online news, not online, news portals, news channels. Then there are news portals and web channels online as well. And then you have social media platforms that act as some sort of citizen journalist platforms and opinion platforms and expert platforms for you. So there are so many platforms in which media acts through, not only the print and news media that we see on a regular basis. So there is this distinction, there is this change. But there will be, as we discuss further ahead, we will see that there is a small difference in how media runs, trial, or the concept of trial by media runs on conventional medium and on new gen social media platforms. With that, you all know that it is under Article 19(1)(a), the right to freedom of speech and expression, that media gets its due, or gets its right to express their opinions, ideas, thoughts, whatnot before you. So Article 19(1)(a) of the Constitution, right to freedom of speech and expression, is from where the media derives its right to express the content that they do express and speak on the content that they want to speak. That's the first part. And where does this spring from? Where does this right to explain, or right to share opinions in the form of, as a media house or as a newspaper or as a radio channel, where do you get that right from? It springs from the basic right to know of the citizens. So as citizens, we have the right to know, because we are a democracy. And we are not just any democracy, we are a participatory democracy. Being a participatory democracy, our opinions, thoughts are all needed in choosing who will lead us next. So it is in that process that we should know one of the reasons why we should know what's going on in a society, among many other reasons. So if you go back and look at Supreme Court jurisprudence as early as 1950 in the Bridge Bhushan case, it is already it's from then on it was stated, or it was established, that the freedom of press arises from the freedom of speech and expression, and it's still continuing. And we discuss any case that you take up on in excesses of the press, discussion on press related matters, you'll always see reference to Article 19(1)(a), and as that it is the point from where you derive that the press media derives their right to express their opinions as such. Now, why do we why do we give so much of significance to trial by media or reporting? Let's reduce it to reporting by media rather than trial by media. Why do we give so much of significance to it? And why are we talking about it in a negative balance rather than a positive balance? See, the fact that media is the fourth pillar of the democracy is, again, from the fact that public opinion, mobilizing public opinion, giving access to information to public, and all many other things put together. Now, the fourth pillar of democracy being media houses, newspapers, news channels, all those entities. The significance of it lies on the fact that it can act as a check towards state excesses in the form of legislative excesses, administrative excesses or executive excesses, and judicial excesses too. So the media houses, when they report on all actions of the state, be it legislature, executive, or the judiciary. The essential understanding should be that they act as checks. They put them on their toes. They draw a line of specific kind of behavior, and if they step out of that line, the press gets the chance to take a check, to tell them go back, and they get a chance to tell them off too. So that is one of the major reasons why we consider the press as the fourth pillar. And as the fourth pillar, it is pertinent that they do their work as the fourth pillar is expected to do or supposed to do. Now, what kind of media do we need? What kind of media houses do we want? In the Siddhartha versus case was a state of NCT Delhi. It was the court went on to discuss on what kind of media do we want. Now, what kind of media do we want? In the sense, do we want media which conflates information, which exaggerates, or do we want an informative media? The choice is pretty clear and simple. We want an informative media, and we want the media to share legitimate content. We do not want them depreciating themselves into gossip columns or page 3 columns. Not that there is a problem with page 3 content. I'm just telling you, especially with matters that are sub judice, matters before the court, we do not want them giving unwanted information that might interfere with the administration of justice, content that might cause or violate rights of the accused in the paper, because it is again it's violating the fundamental rights of the accused, and it will interfere with the administration of justice. Now, when we say administration of justice, what do we mean by administration of justice? So in the very, very, very recent Nilation of Lakha case, the Bombay High Court gave a beautiful description as to what is meant by administration of justice within the Contempt of Courts Act, and that was what they were discussing. When we talk about media trial, one question that will definitely pop up in your mind is regarding what's the big deal? We have a Contempt of Court Act. We can definitely use that to restrict these entities from going or doing something wrong. That's a discussion we'll have sometime late. But for the purposes of administrative justice, we should discuss this. So when they are talking about administration of justice, it was explained that it means what the means that is required to achieve justice under law. All that can be done, or all that falls within the scope of means to be used or resorted to in the process of administering justice, in the process of giving justice, can be included under administration of justice, and that it shows no difference, be it civil contempt or criminal contempt. So in the process of administration of justice, be it civil or criminal, the court can give directions or can involve in such matters, and the contempt of act does not limit its scope into one term of contempt alone is one of the outcomes of that particular case. However, coming back to media trial, we are concerned with the conflicting rights that come out of trial by media. When you remember me telling you that trial by media is essentially not the correct term, because can a media house run a trial? And if such a trial happens, how do they punish? Trial, punishment, and every other aspects that go along with trial is only possible under a judicial system, and a parallel investigation, a parallel discourse on any content, any matter within matters that are sub judice can be detrimental in the administration of justice. Not this is general administration of justice, not the discussion we had a few minutes ago. So, in the administration of justice, or when matters that are sub judice, when matters are getting sensationalized, what happens when media houses or newspapers or magazines start writing and spreading information that have direct relationship with the outcome of the case, direct relationship with how the case is being run? As you know, the freedom of speech and expression is from where the media houses get their right to discuss or speak about or write about their opinions, because one has the freedom to publish all that your opinions and your ideas in all means possible, and the Supreme Court has recognized it in a number of cases too. However, this right that they have, fundamental right a person has in order to express his opinion, share his ideas in any matter, where uh, where where is the limit to this right of freedom of speech and expression? And that is what is the question here. By trial by media, it's just excessive reporting by media, where media reports content and it takes the form or guise of a trial, takes the form or guise of a investigation, a matter of a kind of discussion on the pertinent matters of the case. This is what we see as media trial, and this is closely related with their fundamental right of speech and expression. And this stems again from right to know. Where do we draw the line, and what are the rights with which this particular right, media trial, is in conflict? The conflict actually is with uh, right to fair trial, it can be right to fair investigation, it can be to the principle of presumption of innocence, it can be with related to the privacy of people who are involved in the case, be it neighbors, be it relatives, be it any person who was directly or indirectly affected by this particular act, a particular violent act, the victim, the victim's family, the victim's neighbors, relatives, etc., or the accused's family, relatives, community, etc. So the privacy of these people involved and also their future life are matters of concern here. Now, whenever we discuss certain matters of balancing out of fundamental rights, or when two rights are in conflict, uh, the usual way is to weigh it out. And if you weigh it out, you would see that there is so much of things putting the media trial under a lot of heat. Firstly, the right to fair trial, which is a fundamental right under Article 21 of the Constitution. The Supreme Court has reiterated it in a number of cases, and I don't want to bore you with the details on those cases. So, right to a fair trial is a matter of fundamental right. Now, what all comes within the scope of a fair trial? An essential part of fair trial is that you're presumed to be innocent until proven guilty. That presumption is out of scope, especially when media tries to report you as the person who actually committed the crime. Think about the Arushi Talwar case. I'm sure you were quite young when this case happened, but the final decisions came a few years ago. When Arushi died, it was a servant who killed her, because the servant was not seen anywhere. Once the servant's body was found, it was the parents who killed her. The media declared the entire thing even before the autopsy report could come out, even before much like proper governmental, proper authority-based information could come out. That is what we call, that is one form of media trial. We saw this in the recent SSD case, the Sushant Singh Rajput's case as well, where they declare what happened, how it happened, who did it, when they did it, lots of conjecture, lots of imagination. We also see a bit of it in the Tarun Tejpal case, where where he was he's alleged to have sexually assaulted one of the junior members of the team. In that particular case, a video was leaked, and this video was on prime time news channels. Panelists were discussing on whether the conduct of the people involved amounted to sexual assault. The news readers, the anchors of the show, put out leading questions, engaged the panelists in such a way that they were deliberating on matters that are sub judice, questions that are relating to evidence that was before the court. So one is where they declare the accused, one is where they deliberate on evidence. We saw their deliberations on evidence in the Sushant Singh Rajput case. Before that, in the Jia murder case, Jia suicide case, there were a lot of such cases, prominent cases that the evidence was leaked. Discussions on substantive matters of the evidence were discussed on live television, and this was then taken up by public and community to mean different meanings, especially when Arashi's father and mother were acquitted and the case still remains unsolved. The community has a different perception altogether. Now, the question of presumption of innocence until proven guilty is out the window because media houses asserted or claimed that this is the person who murdered the child, or the parents murdered the child. The stigma that sticks to being called an accused in as a murderer of their own child, it's not something that you can redeem your reputation from. The society does not let you forget, and especially since the case is unsolved. So the presumption of innocence goes out at first. Secondly, the right of a fair investigation. If evidence is leaked, if people are discussing on evidence that are for the eyes of the court, the concerned lawyers, and the administration in general, how does this affect a case? So the Bhima Koregaon case. In this case, there were 13 letters written between parties, the Maoist group, and also the other parties involved within the matter. And these were leaked. These were leaked, and those letters lost the status of primary evidence, which could maybe get a positive outcome or a proper conviction. Those 13 letters will not have the value of primary evidence because this was leaked and discussed in media, and it has lost at least some amount of veracity in the eye of law. So tampering with evidence, giving discussions on these things, all these things affect the value of a trial. All these leads to the possibility of, not the possibility, the situation wherein the accused does not get a fair trial in the process. Now, the right to fair investigation goes both ways. Right to fair investigation falls within the scope of right to fair trial. The Supreme Court has decided this in the Gangaram case was the state of Madhya Pradesh, that it is a fact of fair trial. The right to investigation is a facet of fair trial under Article 21. So given that right to investigation, right to a fair investigation is part of Article 21 under right to fair trial, how can you ensure or assure the family that the right person is caught, or the right or the accused that he's getting the best out of the criminal justice system? So it also goes for a toss when you're talking about right to fair investigation. The accused requires that the matters that are investigated remains within the limits of the judiciary, within the limits of people who can appreciate evidence, appreciate the nuances of forensic evidence. The judges, advocates, forensic scientists, experts who are handling the matter. When it goes into public domain, necessarily all these are public documents, but when sub judice, when these matters goes into public domain, what I mean is when public gets access to it by information being leaked by maybe the authorities themselves, or because of some other, by any other means, these come under a lot of scrutiny. This leads to affecting the investigation, wherein on one count the value of the evidence or the significance of the evidence is lost, and secondly the investigation being derailed by so many local investigators, both in forms, especially cyber sleuths of our times who slew the way in Facebook and other online platforms, and also the general private investigators who go about because they are interested in the case. All these things can affect the way the investigation is run, information is analyzed. This is where we take into consideration the psychology of the people involved in this particular process. Not talking about the trial, but the entire administrative process. Now, I'm not so sure whether you've heard of the Cecil Hotel cases. There's a hotel called the Cecil in the US, downtown Los Angeles. Now, recently, the Netflix came out with one series, a set of CDs on the disappearance of one Eliza Lamb in this particular hotel. The hotel is infamous for a lot of things, and she goes missing in this hotel, and certain information are given to the public, but certain information not. As a result of which, the cyber sleuths started investigating from their own end, looking up videos, looking up who all stayed there, who all lived there during that particular time. A lot of people started acting out, investigating, giving interpretation of various things that happened. So there was this one particular video of her entering and exiting an elevator, and some parts of it were given to the public and some parts were not. So this is not leaking information. This is official release of a particular document to the media houses to be given to the public. There is a difference in America and India in the fact that freedom of press is specifically stated within the Constitution, but in India, it's implicit in Article 19(1)(a). The freedom of speech and expression, freedom of the press is implicit within 19(1)(a) when compared to the explicit statement in the American Constitution. So, the Cecil, Eliza Lamb. So, Eliza Lamb was missing. Nobody knew where she was. The last video was of her entering and exiting an elevator, and her body language was not what you would call a normal. There were some changes, there were some abnormalities that people associated with it. People said that the Cecil, being infamous for many violent crimes, it was the act of a very dark evil spirit. There were people who said that she was attacked and killed. Some people who said that she would have run away. There were so many versions possible. And was also one version of people who were actually attacking the identity, attacking this particular woman for behaving in a specific way. Later on, it was identified that she was having certain mental challenges, and she was under heavy medication for the same. So there are two. The problems is, one, the victim's family is constantly listening to this, have access to news, and are constantly traumatized by this reporting, and that never stops. It's breaking news. And then the cyber people, the people who live and breathe in the cyber world, they not hack around. They look around, they come out with information. And there was one hard rock metallic musician who was targeted by the online sleuths to have actually committed a crime. I forget the name of the artist, but this particular person had a video in one of his Instagram or Facebook feeds where he said that he was staying in the Cecil Hotel and with showing pictures and things like that. Some cyber sleuth stumbled upon this particular video and made him quite famous and called him the accused, called him the murderer of Eliza Lamb, even before they had any idea as to what is the status of Eliza Lamb, whether she just missing or she just went off the grid, or whether she is actually something bad has happened to her. So once when her body is discovered in the water tank, there is even more conjecture as to how the police missed it, how the investigators did not note this, how the hotel staff did not put in extra measures to prevent people from accessing the terrace. A lot of information about this concerning the autopsy, why it was delayed. A lot of conspiracy theories flooded not only mainstream media, but also online media. This is one classic case of uh, where media trial just went wrong on so many different levels. Um, uh, Not just media trial, but also online media trials, where this one person was accused of being the murderer. It sent him to a facility where he needed a lot of help to return to his normal life. He stopped making music. So cyber sleuthing is one of the potential dangers of media trial or trial by media or excessive media reporting, as you may want to uh, uh, call it. Yes, Morbid. Yes, somebody posted the name. Thank you. Somebody saw that series. Good. Morbid. Yes, his name is Pablo Vergara. So yes, he is still suffering from issues related to that. What I want you to understand, this is just one of the many examples of how media trial can go very, very, very wrong. We have our own examples in the Arushi Talwar case, the very recent Sushant Singh Rajput case, where the declarations are made, people are accused, families are destroyed in the process of exercising one's right to express ideas and opinions and get them published. Now, having said that, all these things have a direct impact on how the investigation is run, how the trial proceeds, and it necessarily violates all the presumptions of innocence, of until proven guilty norms that the world runs by. What are other rights? These are popularly associated with media trial and the consequences of media trial. What are the other rights involved? What are sorry, before we go into that, there is one specific category of people who are overlooked in terms of media trial. uh, the witnesses, the people who can positively contribute to the outcome. There are quite a number of ways in which witnesses can be affected. One, they can be made to turn hostile. There is a possibility where this is for the victims. As I told you, the fair trial and fair investigation goes for the accused as well for the victim's family and the victim's friends and family, in the sense that they require justice for a harm committed to them. So when a witness turns hostile, it changes the outcome of the case. If it's a very valuable witness to the case, it changes the outcome of the case and also justice to the victim and the victim's family. So their right to justice is also affected in the process. And the second thing that can happen to a witness is that a witness might be too scared by himself to appear before the court or give. There are other means of acquiring the presence, ensuring the presence of a witness, but that can also prevent the amount of attention media showers on a particular case can also affect the confidence of a particular person to come forward and say, I saw this, or I have pertinent evidence relating to this particular matter. So, the significance of media trial in terms of proving a case, not the significance, the adverse impact of media trial, excessive reporting by media in any given matter, is also lies in the fact that a probable witness, not an existing witness, a probable witness or a possible witness can can be can back out because of the kind of attention this kind of case can bring, not only to him, not only to them, but also to their family. Excuse me. So this is not an isolated event. Crimes or violent crimes or outcomes of crimes are not restricted to the victim or the accused alone. It also goes into the life of the witnesses. So recently, the Abhaya case, when the decision came out, one witness was praised, lauded by the both the media and the online community for staying true to his words and also testifying against the accused. Now, this particular person was dubbed I'm not going to state the word that was used to. It was like a nickname of sorts. I'm not going to state that. I find it personally offensive. Uh, Whatever his antecedents, he was an honest witness who managed to stay true, managed to testify and give an outcome for a case. And we saw how the daughter of this particular witness made a case before the online people online, before the media, not to refer to him with that particular nickname because nobody calls him that, and it was actually the media who coined that name for it. So this is not just the trial by media or excessive reporting or media trial or whatever you want to call it. It does not, the impact of it is not restricted to the case alone, but also to the families of people who can actually make a difference in a particular case. It extends to all of them. And it is also the possibility of actual threat, physical threat to the people involved in a matter. There are a number of cases, very many famous cases, where you can look into and see witnesses turning hostile and then not hostile and then again turning hostile. All these are a result of excessive reporting, giving identities to witnesses, their locations, their whereabouts. Uh, the posting pictures and videos of people, the victim, the accused, the witnesses, all not online, that's a very bad term, on media, be it on news, be it in newspaper, or on sharing it on online media. All these things create real danger to them as a person, as an individual, but also to their life beyond the trial, beyond the scope of this trial. When, if and when a particular person is acquitted, you make them target of the community who might have a different opinion altogether. And that is where we come to a point called majority illusion. We won't discuss that now, but we will discuss it later. So when a particular person is acquitted, you know his face. You have some idea of where he lives or where he is from, because when they report with details of who the father is, who the mother is, where they live, all these things. And you've essentially made him a target to a group of people who truly, him or her a target for people who truly believe in that particular person's guilt. And there is, who did not value the decision of the court, because their opinions, their minds have been occluded by the fact that the media reported very vigorously and very fervently on this matter and claimed a lot of different things and discussed a lot on evidence and made expert panelists discuss on evidence and give their opinions. They'll have lawyers discuss on evidence. They'll have forensic experts discussing on evidence. Now, what we fail to see is that there are what you understand and I understand, but the public necessarily need not understand, is that law can be interpreted and evidence can go either way. So to people on a panel, on a media house, on a news channel, they don't have access to the entire evidence as such, but bits and pieces. Based on these bits and pieces, they discuss and come to not necessarily a verdict. They say possibility. This may be the reason. This may be the outcome. So this is the reason why we can say this particular person is guilty. They only speak on possibilities, but they are discussing on matters that are relevant to the outcome of the case. When they do so, the public tend to have more, media has a very visual impact, and people tend to form very, very strong opinions on these matters. But as lawyers or law students, you would know that the judiciary operates or assesses evidence in a different light. And the details of evidence, be it blood spatter details, be it angle of entry of the weapon, be it the trauma, the instrument that causes the blunt force, be it DNA evidence, all these things are assessed on the specific technical specificities. There are very peculiar standards, particular standards, not peculiar, that we affix to evidence. And unfortunately, the public is not privy to that knowledge, which can lead to their losing trust in the criminal justice system and also the judiciary, and also the criminal judicial system involves everyone, but to be more specific, the police, the investigators, the forensic scientists, and the judges. People might lose their trust on them, and that is one serious issue we might have. And since there is mob mentality in our community, in our country, this can lead to the accused being a target, not only to the community who feels strongly that this particular person is guilty, but also for the victim's family members too, who would definitely feel that they have not been given the justice that is due to them. There are judicial recourses in order to get this matter maybe relooked into, revisited, but then again, emotions when running wild can create more problems than we can even think of. What are the, having said all these things and also discussed the possibility of the witnesses, the privacy, the safety and concerns of witnesses involved. There are other factors which I did end up mentioning while discussing all this. That is the rights of the accused and the victims, family members, relatives, friends, and everyone. So the recent cases, the one that is known to every one of you, would be the case of Suraj, who murdered his wife, allegedly murdered his wife by getting a snake to bite her, and learning the trade of taming and interacting with snakes. Now, the veracity of the evidence, the outcome, whether he murdered his wife, whether that was real or not, all those things are matters to be decided by the court. But the media seems to have found a decision, and they have been operating under that. If at all you remember, all throughout the days when this matter was very hotly discussed, the neighbors, the neighbor's son, the neighbor's friends, everybody were giving opinions about the character of the deceased and also the character of the accused. All these things are matters that are sub judice and can prove as evidence in this matter. So there is this case of MP Lohia, wherein the deceased was found hanging, and it was a case of dowry death. It was a matter of dowry-related death, and a magazine, if I'm not mistaken, or newspaper, they published material, they published content which which had information on the deceased, information on the deceased, details of given by her family members as well. And the court said that this can actually prove detrimental in giving out a final verdict, because that pulls out, that can affect the legal, this can affect the case in point, because all these matters are evidence. All these matters are to be finally decided upon by the court. So all these things, discussing evidence, giving expert opinions on these things, publishing material that can form or that might become, not can form, but our evidence, can all be detrimental in the administration of justice. Now, we discussed something about leaks or probabilities where information is leaked either by the authority or given by the authority or some other way they find this material. How does this affect it? It affects the outcome in the form that on one count, it again, presumption of innocence, it pulls at the presumption of innocence. It completely takes away your one chance at actually proving your innocence, not only to the judiciary but to the community. In the olden days, when the media was not so into discussing these matters, and when they had a lot of other things to do, they did not. The only duty was to prove innocence in before the court. But right now, it has become that they have to prove it to the community as well. Not only prove it to the community and get the community to trust you as well. Media trial has done that for us too, for the criminal justice system too. Well, when leaking information, in a very recent case, Naresh Mangla was the state of Madhya Pradesh, if I'm not mistaken. Let me check. Just give me a second. Sorry, Naresh Kumar Mangla versus Anita Agarwal. So there was information leaked, and the court frowned upon it, and was and did say that leaking of information, even if it is selective, can affect the right to a fair investigation, and this can in turn affect a right to free trade. There have been instances where leaking of information, excessive reporting, and unwanted material, I mean, especially sub judice matter being discussed, leading to people being let go because there is no way to arrive at a proper decision in such matters, and it has not a proper decision, but it vitiates their right to trial, or sorry, right to fair trial and right to a fair investigation in the process. So involvement, over-reporting, and interference of these forms can affect rights to a fair trial, and thereby putting the effort of a lot of people over a long period of time in the bin. So media trial has real life consequences, real judicial consequences, real community-based consequences in in our lives, in people's lives that this particular matter is directly involved in. So there is the need to put a limitation on the media. So I mentioned the Nilesh Navlakha case. In this particular case, the Bombay High Court gave out instructions as to what is to be followed, how or what kind of reporting is allowed, and what kind of reporting will not amount to what do you call it, media trial or trial by media. As a, uh, um, and that's a Bombay High Court decision. This was again seconded in this particular case to Naresh Kumar Mangla case as to how the how they should behave, how they should conduct themselves. Now, there is a final say. The Supreme Court is a final say in all these matters. And can we have a legislation to the tune of the decision in Nilation of Lakha in order to ensure that the media do not over-report and create issues for the administration of justice? It's possible, but the limits of it have to be examined. Now, there is the National Broadcasting Association, there is the Cable and Visual Telecast Network Act, and all those things in place, but they do have one problem. There are so many other frameworks in place, but they all have one common problem. They address it post fact. They can only take an action once this has already happened. They do not. There is no way of preempting it. There is no way of trying to control it. And we do not believe in pre-censorship, and that is against the constitutional beliefs, the constitutional norms of our country. So naturally, that is not going to happen. But we can set our principles in order to guide the media in terms of how they conduct themselves. The reason why we need the media, or reason why we need to meet the media to tone it down, to give them a set of guidelines as to how to conduct themselves in these matters. Firstly, because the way they interpret a particular law, even if with the help of panelists of experts or panels or experts or whoever they may be, the interpretation may not be right, or may not be the correct way, or may not be the adequate way in order to impart justice, or that may not be even the way the judiciary might interpret it. And that can amount to disseminating information to the public, which can create a lot of confusion, affecting the deterioration of trust upon the criminal justice system. That's the first thing. Secondly, this can lead to a lot of information being spread using social media, unnecessary information being spread over social media. Thirdly, we need them not to contaminate crime scenes. We need them not to leak information that are detrimental. We need our evidences to remain evidences and confidential. We need to protect the identity of the accused until he's proven to be guilty. We need to be able to protect the interests of the accused family members who are not to be blamed for a particular crime because they are not accused. And of course, even if the accused turns out to be guilty, his or her family does not lack the right to live or have a life of their own choice. We also have the duty to protect the witnesses, the people who can actually give an outcome to this particular case. And the media cannot interfere in this matter and pollute a particular case and affect it detrimentally. We need to create guidelines to be effective guidelines that can help in monitoring and controlling their behavior. And at the same time, we should be also able to create a framework wherein the victims of such media trial can get redressal, um, uh, either as a tortious civil defamation suit or a criminal suit of defamation is possible under the current law. But can you equate the defamation laws, what you have learned, be it tortious, be it civil, or be it criminal, can you equate the defamation suits suits to a media trial suit where there will be publication, but the kind of publication with the kind of effect, the irreparable damage that it causes, can you equate the redressal to be given to a victim of trial by media can you limit it to just defamatory suits? That's always possible. Can you limit it to that? That's one major question. There is a system in the UK wherein compensation is offered to victims of people who have been targeted by media trial. But can such compensation alone help in given our societal fabric, a societal construction? What will be a solution to this problem? How do we redress this? When identities are disclosed, when people are constantly going to be watched and monitored, and community life, social life becomes difficult for both the acquitted accused and the victim's family and the witnesses and all people involved in this entire entire fiasco, not fiasco, entire case, a particular case or cases. Having said that, we need to quickly wrap up, and there are three things that I want you to consider. Firstly, media trial does not end with newspapers, magazines, and news discussion. It goes into social media as well, and we are all bearers of information. Now, Ray Stewart, he claims that there are three kinds of crimes or three kinds of incidents that media is very eager to report on. One is sinful crimes of the rich, sinful events, that the sinful or passionate crimes that are committed by the rich. Second is regarding psychotic killers, serial killers, and things like that. And third is on the abuse of power. Now, as much as we might see the second and the third, we get a lot of attention for the first one. And that is one of the reasons why there are so many online media houses, and online media houses run on such information that sells, that has consumers, or that have consumers. So right now there is the change in news or change in content being delivered into becoming products, given the TRP scam and all the associated things that are happening around our country and all around the world. News have become commodities capable of being consumed by the public, and this commodity needs a check, and it needs a quality check, and that quality check is what we want in terms of guidelines and safeguards by the state or by the Supreme Court. Supreme Court, not necessarily, because that will be excessive in terms of their power, which is to adjudicate. If it will be more effective if it comes out as a proper, not as a guideline, but as an effective law from the state, not state center, the state, the concept of the country. And then that's the first thing, that social media can actually exacerbate the effects of media trial, and then we all will become complicit in media trial. Each and everyone who reads such a report, everyone who shares a report, we are all part of the very icky thing that we call trial by media. Then the second thing that I want you to remember is that you remember me telling you about people who strongly feel on the guilt of a particular person, or the association of a particular person, who have strong opinions about guilt by association, all these things. This is possible by a phenomenon called majority illusion. Now, this is a paper written, and it's a very scientific paper, but they talk about how networks and networking creates an illusion that we are a majority. In very simple terms, we are all connected. We are all connected through this meeting. Think about all your friends on Facebook or WhatsApp, and think about how many people you follow on YouTube. Think about the number of people these YouTubers, Instagrammers, all those influencers have. We all form networks, circles of networks. So the impact we have is limited into a circle. We choose our friends, we choose our network, and we are constantly in connection with them. So whenever we choose friends, whenever we choose groups, it's always going to be people with whom we can align our thoughts and ideas to. When you work, you have a group of friends there who might end up syncing with your already existing friends. You choose to subscribe to YouTubers, people who appeal to your thoughts, people who appeal to your aspirations. And all these things put together, you fine-tune the information, or you regulate the nature of information and content of information that comes to you, which gives you the feeling that I am right, because by default, everybody in my group thinks this is the right thing to be done. So naturally, we are the majority. This is the illusion. It may not be so. Let's say that I'm connected to 10 people, but out of the 10 people that I'm connected to, one person, maybe a YouTuber, maybe an Instagrammer, or any kind of influencer, or any kind of social media, that particular person might have 10 million or 1 million subscribers. So because of the number of people who follow him, it also gives you a confidence that if at all that particular person is describing or discussing something related to a matter, or giving an opinion, you feel, maybe you agree or disagree, but there is a probability that some of the people who have such networks might feel aligned and might feel that this is the majority opinion, and thereby creating the illusion that my majority is the right majority, and this is the majority, this majority, or this, the opinion that I am living in is the right opinion, and this is what everyone feels like. This is what, or this creates the mob mentality or the community mentality. That this is one thing that contributes to the mob mentality in future, or this further can contribute to consequences like cyber sleuthing, grouping into people who into like sharing of information, mass sharing of information online. And this can further lead to more problems for you if at all you're sharing fake news, you're sharing fake ideas. All these things can have long-term consequences to people involved in this huge web. And thirdly, and most importantly, is it so important that we give so much of power to media? Is it so important that we have to restrict their reach? Is it so important that since we are Gen X, Y, Z, whichever Gen you are, and I am in, I'm not so current with the new terminology associated with the generation that's currently ruling social social structure, social how do you put it? Determining what you are to be called. So I do not know what is the new generation, but let's say all of them put together are not subscribers to the conventional form of news. You do not not many. This generation is not fond of newspapers, not too fond of news channels, but we consume information from online media, online content makers. We consume information from Facebook, and all media houses have Facebook presence. All media houses have YouTube presence. All of them have presence in all the major medias because they know the demographic that they cater to have shifted from the conventional medium to the online medium. It will affect you. The media trial will have consequences, major, huge consequences in comparison to what we have to 10 years from now in comparison to what we have today, because media and communication has made it really impossible to keep anything secluded or look isolated in one place. Think about the number of internet lockdowns we've had, the legality, constitutionality, all of those things apart. The number of times communication had to be shut down in order to maintain law and order is one example. Proves the fact that information travels at a much faster pace than it did a few years ago. So our broadcasting rules, our guidelines, our legal system should evolve to match up the challenges of the increased potential of media, increased potential of information technology, and also the increased potential of social media users and influencers who have the potential of actually creating consequences, real life consequences to all the people involved in this, in each and everything that is made into a trial, made into a kind of parallel trial by the media. It is significant. You are influenced. You are part of the system. So it is pertinent that we have some regulations in place to prevent and restrict the consequences of trial by media. So I think I have used up a lot of time. I'm really sorry. I was supposed to stop ages ago, I believe. But thank you for patiently listening to me. There is so much content that I refer to in this process. I'm sorry you do not have a PowerPoint slide or anything. But if at all you have any questions, I'll be happy to have them now. If you can't ask them, you can put it in the chat box too. Yes, I think that's pretty much it. Nobody has questions. That is good. Thank you.
Ma'am,
for having me.
there is no doubt. Shall we
Yes,
move on to a vote of thanks?
Oh, it was a
Hello,
vote of
ma'am.
thanks. You are audible, yes.
Ma'am, I think there is no doubt regarding the same.
Yes, thank you.
Shall we move on to vote of thanks?
Yes.
Rojit, I invite Rojit to deliver the vote of thanks.
Good afternoon. It is my privilege to have been asked to propose a vote of thanks for this session. On behalf of Government Law College Trivandrum, the entire organizing crew, and all the members of this course, firstly, I would like to thank Dr. Biju Kumar sir and his team for bringing forth this educative venture, this opportunity to all of us. Thank you so much, sir. Now, I would like to express my sincere gratitude and appreciation to Professor MANEKA Shastram. Ma'am, amongst various other things, she explained to us the basic concept of what a media trial, what we refer today to as a media trial is, which is basically a case of excessive journalism. She explained to us the constitutional provisions from where the media derives its powers, specifically Article 19(1)(a), that the media acts as constitutional checks to the abuse of power by the state, the fourth pillar. She also explained to us the presence of this conflict of rights that comes into play when when a media trial is started. She also explained to us various instances of excessive journalism, and she brought to light the different kinds of persons which are affected by these media trials. Not only victims and their families, but also the witnesses, people who can actually contribute to the case, and the accused and their rights. She talked to us about the accused and their rights, or rather, in this case, the violation of their rights. She explained to us how these parallel investigations cause a lot of unnecessary and often wrong information to be circulated through various media platforms, and then she left us with some very important points to consider in the case of media trials or parallel investigations, and the possible solutions to remedy the same. Thank you so much, ma'am, for making today's session so clear, so educative, and so inspiring. Thirdly, I would like to thank all the student colleagues and all the speakers and the members of this session for being present through the session and presenting their ideas. Thank you so much. And lastly, I would like to thank the organizers, the web admins, for being continuously at work behind the scenes, making these sessions seem so smooth and problem-free. Thank you so much. Thank you all.
Thank you, Rojit, and thank you everyone for having me. I hope this was useful to you, and in event you have any doubts, please let Meena Kumari ma'am know. I hope to help you in any way I can. And so thank you for having me. It means a lot to be back in my college, even if it is virtually. So thank you everyone. It was nice to meet all of you. Thank you a lot, and have a good evening.
Thank you, ma'am. Thank you.
Are we speaking now? I'm really sorry. Just shush me.
No, actually, ma'am,
It's okay. It's okay. It's okay. It's okay. I was just joking around. So thank you guys. Have a good evening, all of you.
Have a good day.
Thank you, ma'am.
Bye.
Thank you.